Welcome to the Future Media Podcast. I'm Ricky Sutton.
And I'm Alan Chappell. And this podcast goes deep into the collision of big tech
and the future of the world.
We explore how companies like Google, Meta, and Apple are impacting each of our lives.
I'm an investigative journalist.
I'm a privacy lawyer.
And every week we speak with experts to bring the unreported details into the light.
Welcome. It is a beautiful Friday morning here in New York City. Ricky is traveling this week, but I'm joined by my friend Tim Cowan, who represents a group called Movement for an Open Web, or MOW. But before we bring Tim on, let me set the stage. Frequent listeners to the Future Media Podcast know that Ricky and I have spent lots of time talking about the various competition trials taking place around the world against big tech. We've dedicated a number of episodes to the antitrust trials taking place between the U.S. Department of Justice and Google, and I even think we did an episode covering Canada-specific regulatory concerns with respect to Google's ad tech stack. As Ricky likes to point out, the United States is only a percentage of the world's population. So, in addition to Canada, there are also concerns and in some cases litigation coming from all over the world with regulators in Australia, the United Kingdom, South Korea, the European Union, and even individual EU member states, all hoping to address the competitive concerns raised by Google. Today, we're focusing on the two cases underway between Google and the U.S. Department of Justice, as well as the attorney generals of a number of U.S. states. The first case, initially brought during the first Trump administration, focused mostly on Google's dominance in search. And the second case, filed in January of 2023, focused on Google's dominance in the advertising technology space. Google has lost both of those cases, and we're now in the remedies phase of each, where the court, having ruled that Google is a monopolist, now needs to determine how to reset each marketplace to the point where it's competitive again. To date, the trials have been conducted separately, but some are calling for the remedies to essentially combine the two cases. To discuss all this, I've got Tim Cowan, who is chairman of the antitrust practice at Preschool & Company. He is representing the Movement for an Open Web. Hey, Tim, how are you?
I'm very well. Thanks, Alan. Great introduction.
Good. I bet it is probably not quite as nice right now in the UK as it is in NYC.
It's baking,
not to rub it
it's
in.
baking hot here, so I can't turn my camera around and show you what I'm looking at outside, but it's lovely.
Oh, wonderful. Well, first, tell us about the group you're representing, Movement for an Open Web. What is MOW, and what is MOW trying to achieve broadly?
Okay, so we, if you go back to 2020, I've been running a thing called the Digital Policy Alliance, which is still, going on, which is a group in the House of Lords here in the UK. So I'm co-chair of that as well. This is a public policy group chaired by Lord Clement Jones. And we were making representations to the CMA in relation to online markets. That originally came from the fact that there'd been investigations into what was happening to newspapers, smaller regional newspapers particularly, being very adversely affected by online advertising and online advertising taking all of the income away, so that our news publishers have been very severely threatened, and their income from advertising has dropped. And this is a major problem from a free speech democracy perspective, because if you don't have money to local newspapers, you don't have local journalism. If you don't have local journalism, you've got nobody to hold people to account at local level, and you start having a major issue. So that was really where I came in, and there were hearings taking place before the CMA, and a young guy called James Rosewell, who's a computer engineer who runs a small business, and he's the only member of Mo that I can talk about, because the other members have a massive problem with retaliation risk, right? So,
I'm well aware. I mean, when you go up against big tech, I've had the experience where they sometimes come after your clients, sometimes they come after your business interests, and it's something that really needs to be navigated.
Yeah. So, going back over time, I was at Sidley Austin, and I've done antitrust and regulation for many years, and dealing with these sort of issues. So James basically was asking a question of the case team. What are you going to do by way of remedies? This is 2020. And he said, the car's going to crash by Christmas. What are you doing about it? You're admiring the problem. You've analyzed it very well. We know that Google's a monopolist. It's been a monopolist for a very long time. What are you going to do about it? And one of the officials said, well, nobody's asked for an injunction. Now you've got to read your British official. When they say something like that unprompted, really, I mean, he didn't say, can I get an injunction? It was, nobody's asked for an injunction, which is a fairly strong indication of, you should really try and ask us for an injunction, guys. So James turned around to me and said, do you know how to do that? And I said, yeah, let's do it. So we put together from our mutual contacts, across everybody that was, involved in digital markets. And I've been writing about digital markets and representing businesses originally, shopping businesses and mapping businesses. I represented a business called Video Jug, which was the first, it tells you how long ago it was, because Video Jug was the first 4-minute video that tells you how to do certain things. So it was famous at one point for how to dance Gangnam Style, right? Now that dates it, right? And how to make a chicken korma in 3 minutes, and how to fix things with, you get a scratch on your car. And they had 100 and something million worldwide, viewers daily. It was pretty good. It was going very well. It was 2007, right? And I think what happened was that Google bought a video business known as YouTube. And guess what happens? Suddenly their visibility in search results collapses, right? So, we'd seen this before and seen what kind of happened. So the idea of Mo was to create a whistleblower vehicle, basically. So it's whistleblower witness protection. So when you think about courts and court processes, it's very common that you have whistleblower protections where the person who's actually providing evidence can be severely harmed. They can be retaliated against. One of my very early cases as a very junior lawyer, in long time ago, was a Stanley Adams case. I got the tail end of that. And Stanley Adams was a complainant to the European Commission. Anyway, things got screwed up, and the defendant found out who the complainant was, fired him, pursued him through the courts, sued him for breach of confidential information. It was actually a business based in Switzerland, and they granted the injunction. The guy was treated appallingly badly, but I mean, that's what can happen. It can get very personal. So you've got to be extremely careful in these cases. And we get asked all the time, so who are the members? Why don't you disclose the members? Is there something, nefarious about it? We can't. I mean, it would just be, if you don't ever want to be found in Google search results again, what does that do to your business? I mean, it's impossible. But to give you an idea, computer science people who are involved in ad tech, people who are involved in the supply chain of, providing ads, advertising exchange, technology, DSP, SSP, right the way through to publishers, newspapers. As a firm, we represent about 500, 600 clients that are tech, media, telecoms. So, if you look at what we do, it's kind of drawn from our book of contacts.
Okay, so you guys were talking to the UK's Competition and Markets Authority, which is really their competition regulator. And the competition regulator hinted that, maybe somebody could ask for an injunction. And so you guys saw that as an opportunity. You went in and asked for the injunction. What happened then?
So what we identified was that there was a particular problem relating to Google's browser changes. And what they were proposing to do was to block publishers' ability, essentially to interfere with a publisher's ability to advertise and tailor advertising in a way that the end user actually sees things that are useful. And they use cookies, and they use lots of different technology, but essentially, and it's important that this isn't just thought of as cookies, right? Because it's actually a whole series of things that are enabled by the HTTP protocol. So the way the internet was originally constructed is that it's an open protocol that links websites to each other, and you've got hypertext links, but you therefore need what is actually a type of address. So outside the front of this building here we're in a thing called 4 King's Bench Walk in the Temple in London. That's the address. Everybody knows the address. You can't send a message to someone in the old-fashioned days with a post if you don't know the address of the building you're sending it to, right? So you need a URL address for a website. So the website address has a URL in it, and there is information available, and you've got the user agent string of information, which is available as a consequence of a computer talking to another computer. You know what the pixel count is, what the memory is, those sort of things. Very important to publishers, because if I'm accessing a newspaper in the UK from the USA and the quality of the line isn't very good, or I'm accessing it from an old phone and I'm in Africa, you can alter the presentation of the page so that it's optimized for the type of device that's at the other end. And that device optimization means that actually the thing that you're looking at can be altered in a way that the person can see it better, right? So if you screw around with that, if Google changes the visibility through the rendering engine, the browser, that makes a massive difference to what publishers get to put out and publish. So yes, there's a cookie element to it, but it's bigger than that. And what we said was, look, you shouldn't let them do this because they're proposing to change it. And that's going to change the way, a lot of things work on the internet. So they're basically interfering with the infrastructure of the internet. I mean, if you look outside the building behind you, you'll see lots of other buildings. They depend on a road infrastructure. That's rather like the internet architecture. You can't interfere with the internet architecture just because you're bigger than everybody else. You're interfering with other people's business and how people get to other people's businesses. You're effectively interfering with the internet roadwork system.
So there was a time when Google was big. I mean, they're even bigger now, but a lot of their interests were somewhat aligned with the rest of the business ecosystem. I think over time, what's happened is that Google has made changes that are in their interest, but that are adverse to the interests of others within the ecosystem. So it sounds like, and not to put words in your mouth, but the primary goal of MOW is to change that so that it makes it more difficult for Google and others to mess with the infrastructure of how the web works, so that it ultimately works well for everybody and not just Google and others in big tech. Is that a fair way of looking at it?
Yeah, I mean, look, my first job when I was in law is that I'm a barrister. I was recruited into a big telecoms company called British Telecom, and my job there involved helping to explain to the world's governments that there was this thing called the internet, which would provide all sorts of wonderful opportunities for lots of different businesses to communicate with each other. It's basically it's a layer on top of the communications infrastructure. And all we needed to do was to deregulate the market, because back in the early 90s, there was a national monopoly in the UK. There was a national monopoly, not quite true in the UK, it was already liberalized to some extent, but it was national monopoly in Germany, France, Italy, Spain, every country around the world until 98. So I spent a good 6 years seeking to persuade governments to open up national markets and enable the internet. The purpose of the internet was to decentralize so that you didn't have the complete control over communications infrastructure. And you could have different speeds for different things. So banking could be optimized in a different way than shopping or browsing. All of these different things depend on technology. So we liberalized, opened up the markets, and then along came the, free at the point of use systems, and browsing there was a big battle about, because the Microsoft, browser wars and that sort of thing happened in the late 90s. But the opportunity was always billions of people accessing billions, millions of websites, which is a structure of a market that is essentially decentralized and highly competitive. Now, we did have intermediaries. Intermediaries came along. So you have marketplaces, you had shopping marketplaces, you had, Amazon type businesses came up, and you've got all of those things coming along. But what's happened with Google and Apple is they've controlled the smartphone as a gateway to the internet, and that control then curates the things that people can see, and you can be steered. You can be locked into apps that are on the App Store, and apps only work in certain ways. On Apple's famous case, it's up to 30% payment system. So you're effectively pushed into a subscription model because Apple gets a cut, right? That's the Epic case and the Spotify case. If you look at what's happening with Google, a slightly more open architecture, Apple's is famously kind of controlled and sealed into was originally sealed into the handset. Google's slightly more open, but effectively they're curating a walled garden of what you can see, and they make money by controlling as much of the advertising as possible. Yeah. So, I mean, going back to what happened originally with Mo, we made the application for injunction interim measures in the UK case, and Google offered undertakings, which is essentially what we were looking for, is that you get we really were looking for an order with an undertaking. We got undertakings. And that seems to be Google's practice in relation to a number of these types of cases. What we also did was to make a complaint to the European Commission. And we explained that what was happening with the browser is highly important to how you look at the entire advertising technology stack from the beginning right the way through to the advert and how the advert is served. So in that proceeding, we're talking about the ad tech case. The ad tech case has then been taken in the US. It's the same background witnesses, same people affected. So you've got the ad tech case taken by DOJ, which is the Brinkmar judgment. I think of that as the case that starts with DoubleClick being bought by Google, the DoubleClick ID being blocked, so third parties can't see what's happening over the internet. They have to find other alternative means, JavaScript, cookies, etc. So if you're looking at that, it's basically the same set of issues, controlling what other than the Google system can do on the internet. So whether it's through the browser or whether you look at it through, how the ad tech stack works and how the data flow operates from Google across the supply chain or between different advertising members of the supply chain across advertise and matching, ads and available inventory across advertising exchanges. Essentially, it's software. So what you're looking at across the whole thing is the ability to manipulate the data flow using software.
And so, okay, you've had discussions with the UK Competition and Markets Authority. You launched a complaint and have had a number of discussions with the EU Commission. And then I want to turn to the Department of Justice and the DOJ. Yeah, because that's the, we're now at the point where both DOJ cases are in what they call the remedies phase. So the court has adjudicated Google as a monopolist. And so then the question is now, what are we going to do to fix the issues created by that monopoly? And so thus far, you've got a set of remedies proposed for search and the search ads business. And then separate from that, there are a set of proposed remedies for Google's ad tech case. And what I think you guys are proposing is that those two cases be viewed a little bit more holistically because, well, candidly, I'll give you one example. The most important thing to the ad tech community is not whether DFP or GAM are owned by Google. This is just my opinion. The most important thing to the ad tech community is who owns the Chrome browser. That's a search issue, but it's very, very important to the ad tech community. So Am I understanding you correctly that the goal here is to look at those remedies more holistically? But then that begs the question: how does one do that legally? Because those are two separate cases. And so, can you walk me through that a little bit?
Yeah, sure. So, I mean, start with the issue, as you say, is with the browser. The browser is the gateway to the web, as the way a lot of people talk about it. But I'm not sure gateway really kind of sums it up. It's a portal. I think of it as a window on the web. It's a rendering engine. So what it's doing is it's enabling me to see you. Well, actually, yes, it is on this screen. But that's video, so it's slightly... did I go through the browser to get it? Yes, must have done at some point. Anyway, so if you think about the setting up of a session between my computer and a website or a video streaming system or whatever, all of that goes through the browser. It's not really a gateway doesn't really get it. But so in the search case, what the DOJ are proposing is that the browser, because the way they put it is it's a search access point. The browser is so important that it shouldn't be held by someone who has an interest in manipulating what you see for their own commercial benefit, right? So that goes back to the Privacy Sandbox case that we were talking about, the manipulation of the browser for Google's own commercial benefit. It goes into a lot of activities that we've seen, whether they're browser or search. A lot of the functionality can be in any place, right? But it's the manipulation of the system. So the browser was originally defined under the HTTP protocol and by W3C as the user's agent. Now, it's not really the user's agent when it's owned by one of the principal suppliers of advertising and it's manipulated. And there's controls in place that stop the use in a way that just restricts the market. So there's provisions in the agreement that everybody now knows about between Google and Apple about what happens between the two main browsers, which limit innovation in browsers. I mean, that's just blatantly anti-competitive. Those obviously have to go. But where the DOJ is going is, okay, put that in separate hands, separate ownership hands, right? And we can come back to who might be the best owner there. But if you've got that in separate hands and the person who owns it doesn't have an interest in manipulating it for their own benefit, that's, as you say, in the search case. There needs to then be a monitoring and oversight and implementation of the obligations that are put in the, it'll be a final order from the judge. So we've had a memorandum opinion, we've had a bunch of hearings and evidence taken in relation to remedies, and that's ended now in the search case. And that goes back into the judge. The judge then makes a decision, issues an order, rather like the AT&T divestiture order, or before that there was a AT&T order which required compulsory licensing of intellectual property back in the 50s, which led incidentally to the electronics boom. So you can look forward to probably, if they do it right, a massive economic benefit and big boom in opening up these markets and to competition. I think that you can expect that, but that needs to be overseen. So what was put in place in the Microsoft case, which is envisaged in these cases as well, is there'll be a technical committee. Now, if you appoint the technical committee in one case, but it can only look at a certain set of things, that's kind of limiting the role. Now, there's going to be two technical committees, because you'd have technical committee dealing with search and technical committee dealing with the ad tech case and the remedies in the ad tech case. And again, you're looking at potentially divestiture of AdX, and there's then a risk that the functionality of matching the available inventory with the available advertising will be moved out of the AdX into another part of the Google software stack. Maybe you could put it in Android. That was originally, they tried to put that into the browser in the Privacy Sandbox case. Of course, if they didn't own the browser, there's no point in it. But you see, I'm illustrating the point that this is a software layer across the entire world in a way. And and you could put a lot of functionality in either place. So if you're trying to ensure enforcement of both remedies, coordination at the very least, but you might as well join up the technical committees that are looking at it, I would have thought.
So I would just add that one of the goals within the privacy sandbox, and I can tell you this because I know a number of companies who were speaking with Google. Google would come to them and they would say, "Hey, I fit this spot within, the current supply chain." And Google would say, "Oh yeah, well, we're going to have to reinvent that." So a lot of what they were doing with the privacy sandbox, or at least attempting to do, was reconfigure how all of the various ad tech supply chain components work together, and they were trying to force that. I think in part that was because they knew that some of the remedies were coming in the ad tech case, and to the extent that you can add different opacities to how that supply chain works and make it really difficult, put all of your competitors kind of on their back feet because they don't really know how the marketplace is going to shape out. So that's a deliberate strategy that Google has adopted, is to confuse and to distract the marketplace. But getting back to the DOJ remedies, I guess my first question is, legally, is there a way to compel the DOJ to combine remedies in these cases?
I don't think you can really compel, but because I think it depends on the judge, I suppose, and DOJ could put it forward and say, we think this is a good way of doing things, and judges may well agree. They may not agree. That's for judges, but you can see the efficiency benefits, quite quickly if you look at Google is going to end up paying for all this. So, it might even be in their interest to have one bunch of people to talk to. There's always a downside that you have a bunch of people to talk to get it wrong. So maybe you need a couple of, that's why I say at the very least coordination. What happened in Microsoft was that there was the European Commission remedies. We then had the problem in the US that between the proposal of the remedies, the order that what was happening was anti-competitive, the decision was made. There was then a US election, and a different president got in, had a different point of view about antitrust, and which famously relaxed the oversight. So what happened in that case was that you had Europe. That didn't make any difference, the European remedies, and the technical committee in the US case coordinated quite well with what was happening in Europe and make sure that it all worked across the board, right? I think that's going to happen as well, because the European Commission's got a case on ad tech, right? They took a case in 2017. They were much earlier than the DOJ. They took the search case in 2017, and that led to what's known as a compliance mechanism over here, which really relates to shopping rather than a lot of the other aspects that are in the search case in the States. So it relates to how the search engine results pages are presented. In the way that Google operated, the presentation affected news, maps, shopping, finance. So they're promoting their own products. But because the case was taken by the commission in relation to the area of shopping, it doesn't, on the face of the decision, say anything about any of the others. So Google can quite happily say, well, I haven't got a decision against me about news. So that's led to our, or about finance or anything. So that's led to our Digital Markets Act, which is effectively an antitrust remedy across the board, because it's very difficult to do that in an individual case. So you've got search remedies in the search case in Europe. You've then got the Digital Markets Act in Europe, all designed to hit and prevent these sort of anti-competitive harms that Google is creating. They also address other online platforms like Meta and Apple. But it's not just about Google. And then you come back to how does that coordinate with what's happening in Washington, which becomes the next stage of the problem.
Right. And I guess that's my next question is, okay, so we know that you can't really compel the DOJ to act a certain way. And even if you can, judges are going to do what judges think are in the best interest of a particular case. So what is your approach then to try to get the various parties to look at this a little bit more holistically?
Well, I think the thing that everybody has to think about, and a judge will be very concerned about, is if the order is a paper tiger. It looks like an order, but the issue that you then have is that it's ineffective in practice because it's worked around. So you've got the anti-circumvention risk. And if the order can be circumvented, then that gives quite a lot of discretion for saying, well, actually, here's a fix. Here's a way of stopping that circumvention. Requiring coordination. You can imagine the judge saying, well, whoever's standing up for the DOJ, how are you going to avoid these changes to be made that are going to undermine my order, right? How are you going to address that? Now, one way would be to merge the technical committees to make sure that you've got oversight of both, and that can be stuck in an order. Or you could say, well, there's a coordination requirement, and there will be a need for a coordination across other parts of the globe because Google famously operates globally, and the order is going to relate to Google's activities in the US. Now, it would be clearly a geographical problem if Google operated one way in the States. I mean, how do you divest Chrome for the US and not for the rest of the world? I think that's pretty challenging, but might be technically possible. So you'd want to see international coordination to ensure that you don't have geographical circumvention as well.
No, that makes sense. And what's your sense of how Google would take a suggestion that all of this gets merged? I mean, I can kind of see it both sides, so I'd love your take.
The impression I've got is they're not really grasping the opportunity. One of your country women actually said to me, I don't understand why you get so excited about breakup, right? Why you keep talking about breakup. If you put assets into different hands, that's not going to happen for free, right? So Google's going to make money out of the sale. That's clear, right? And actually in different hands, those assets might generate more money because one of the things that happens when you suppress the advertising markets, which have been suppressed, is that you're not advertising as much in relation to you're not advertising as much as is relevant because you're pushing demand into supply by something which is less relevant than otherwise might be the case in a more competitive environment. So when Google pushes its own products, they might not be as good as a competitor's products. If you actually had a more open marketplace, you would have advertising around that. Now, we saw that in relation to things like maps and shopping and news in the past where they weren't closed down and constrained. That there was a higher volume, yes, at a lower price for advertising, but there was higher volume, so there was more profit in the system for publishers in particular. But I don't see why Google wasn't exactly harmed by that. So if you look at this as the breakup's going to lead to a change, the change is going to lead to innovation. That's going to change lots of different parts of the business and open up. Famously, if you disaggregate a vertically integrated business, there's always a lot of hidden value that the stock markets can identify. So, you can see a way through that this is actually going to generate quite considerable change and I think release quite a lot of energy and innovation as well.
Well, that's the hope. And certainly history has borne that out. When you looked at the breakup of Ma Bell, you even look at they didn't get as far as I think they would like to have, but even with respect to Microsoft, the antitrust approach against Microsoft held them at bay and at least enough to allow for some innovation that ultimately resulted in it certainly helped Google, certainly helped Apple. But what's interesting to note, and we had Gene Burris on a week or two ago, and he pointed out very aptly that, Microsoft went through this 20 some years ago and is still the biggest and most profitable company in the world. So it certainly didn't kill them.
No. which is a very good pointer as well. I mean, I think one of the things that is a bit different in this is the restriction on interoperability, which is at the heart of the problem. So, if you're looking at the browser, that enables people to look at different websites around the world. If you look at how cookies and are used for supporting match keys, which support interoperability across the entire supply chain, modular interoperability is kind of in a computer sense is really what the building blocks of the internet were designed to enable. And so the more open interoperability between what we now call apps, but essentially websites, the more innovation is possible. The more you close down interoperability, the more you vertically integrate, the more you prefer yourself. So if you look at Google Ads as it now is, which generates a huge amount of the demand, and there's a lot of talk in, that Brinkmar's judgment is going to give rise to a separation of the advertising exchange from kind of the Google upstream part of the business, which includes search, right? Well, that's going to give rise the day after the sale takes place. It doesn't solve the problem because the demand at the top end is still going to be a monopolized demand, so that you can take that fire hose of data and you could give it to the new owner and say, okay, give me an exclusive deal. You go back to square one, right? So in the front end of the search, what the search case is looking at is access to search for third parties. Essentially, it's a reseller access model, so that a third party can come in and resell the Google search engine results and the relevance engine results. And that should mean that you could have chapel search, right? And what you could have is a front page which has a user interface designed in a different way with perhaps fewer ads on it. Or you could design your user interface for a particular niche market or a vertical search service or something. And that can lead to a wide variety of different types of search, not just general search. You can imagine, just as a matter of basic economics, that's going to lead to high levels of competition and high levels of differentiation quite quickly. So, and with a fantastic search engine on the back end, it would be, that could be a boon for the creation of competition. And if you've got competition at the front end, you've got less of a problem with the advertising. You can create competition across the entire stack, because at the moment the ad tech stack is just monopolized at stage one, browsing, stage two, search, stage three, DSP, then you've got the advertising exchange, because it's all integrated. You break all that open, then you've got to, which is, you need to then have coordinated oversight.
So MOW effectively was born out of some concerns about Google deprecating third-party cookies in the Chrome browser. There was a complaint made to the Competition and Markets Authority, and that was 4 years ago?
5.
So I would love
It wasn't really born. Yes, the browser case was the first case, because that was the first thing. I mean, Google announced that in 2019, but the concern goes on longer than that, because Google had been excluding suppliers from its search engine results under Universal Search from 2007. Universal Search was a Google, Google put big pictures, interactive pictures up for its own products, right? And denied access to those interactive parts of the search page to third parties. So it gave its own business a leg up, right? And that covered finance and news and maps. I mean, one of my early cases in this was for a mapping company, and then a bunch of other mapping companies that were wiped out when Google put Google Maps at the top of the page. Right. So yeah, I mean, the browser was kind of the latest in a long line. In Europe, we'd had a problem with what was known as the Android case, which is actually about agreements between Google and handset manufacturers that take Android as the operating system for free, but what it comes with is an obligation to put Google Search at the top and a default setting for Google Search, and a suite of other Google apps in the home screen. And before that happened, you used to get lots of different apps from lots of different suppliers in your phones, right? So that's restricted the way in which the market has gone on. Now, that was illegal from 2018. Google got fined 4.7 billion for that one.
Okay, so I think the point I was trying to make, though, with respect to the Competition and Markets Authority, is that there was a process in place for the last 4 or 5 years, and that process seems like it's nearing a close, or at least that's, if you read the recent announcement from the Competition and Markets Authority, they seem like they're trying to extricate themselves from this process. And I guess my question is, what happened over these 4 years, and what can or should the DOJ and the U.S. authorities learn from what the CMA did over these last couple of years?
Well, so there's a lot of things that's happened over the last 4 or 5 years. I think the first thing that is possibly unusual, it's certainly, I think, pretty unique, is the UK has a legal regime which is called the markets regime. So most places in the world have enforcement and merger control. We have something else, which is called markets. And that enables the authorities to go and do a drains up and look at a particular market. So what was going on in 2020 was the CMA looking at online markets and digital advertising. That was the first inquiry, right, which produced a recommendation for a new act, right, which we've since passed, called the Digital DMCCA, Digital Markets, Consumers and Competition Act. So we've been through Parliament, we've got a new act in place. Under that new act, we now have 3 cases, right? There's a case against Google, there's a case against Google, and there's a case against Apple, right? So you've got Google Search, you've got Google in terms of its ecosystem, mobile ecosystem, and there's a case against Apple. Now, what's also happened here is the 2020 report was investigated. The investigation ended up with a report, and that gave rise to the act. That also identified the privacy sandbox as an issue, and it identified the ad tech supply chain problems, which have subsequently been taken by DOJ and Brinkmar, and the European Commission's got an ongoing case, and the UK's got another ongoing case on that, right? Now, we then did mobile ecosystems, which was another market inquiry, which said, look, there are fundamental problems here in the way in which app stores are curated, right? Apple appealed that. That then came back, and that became what's known as the browsers inquiry, or browsers and cloud inquiry. We then did a separate inquiry into cloud computing. And so browsers has been folded into a new case, which is effectively the 2 cases, Google and Apple, right? So there's buckets full of reports. I mean, when I talk about the 2020 report, I'm not talking about a 70-page, nicely written. It's 2,500 pages, and most of the report itself is in 400 and something pages, and then there's annex after annex after annex providing technical detail about how different parts of the market operate and how the supply chain works. So you've got detailed background research into how all of this works, and where we're going now is into a digital markets enforcement regime here in the UK, and at the same time, the European Commission has got, it's still got an outstanding case into the ad tech supply chain. And of course, we know from various things that are said by the authorities that they are talking to each other. I don't think they coordinate perhaps as closely as they might. I think there was a massive delay when the US had an election. Nobody really knew what the Trump administration was going to do, but we've since seen that with the appointment of Gail Slater and is it Andrew Ferguson at the Federal Trade Commission?
Yes, yeah, Andrew Ferguson and Mark Hamer is, I think, running the ad tech case right now.
Yeah, so you've had a change of administration, and if anything, it looks to us that the new administration is even fiercer about enforcement. So they're pursuing the breakup of Meta into Facebook, Instagram. WhatsApp, to unbundle all of that system. And you've got the breakup of Google, which from an advertiser's point of view would be a dream, because you've got so much more. I was really taken by a submission that was done, an amicus submission that was done by Y Combinator in the DOJ's case against Google on search, which is saying, look at this from an innovation point of view. You're looking at this from a Silicon Valley investor's perspective and saying, well, at the moment, digital distribution is monopolized. So if you want to sell a car, a house, a horse, it doesn't matter what it is, right? You effectively have to go through Google or Facebook. And they can control all of that advertising and where it goes and how it works. And that's affecting innovation in everything. So if you break that up, you no longer have monopolization of distribution. It means that all of the supply side, all of the great inventions and innovations that people come up with will have a greater opportunity to make it to the marketplace, make it to the end consumer. They won't have to go through the middleman or the middlemen of Google and Meta or Facebook.
So I'm inferring a bit here, but it sounds like the Competition and Markets Authority has released tens of thousands of pages of reports. It's almost akin to, I have a cousin who's got like 3 or 4 advanced degrees, and eventually all the cousins got around him and said, dude, eventually you got to start your life. and I wonder if that analogy is apt here. At what point does the CMA have enough information that they get serious about enforcement? Now, that's my words. I'm not going to try to put them in your mouth.
No, I think that's a fair criticism. It's a fair, a number of people have pointed out, well, 5 years and a report a year, there's lots of trees that have died in vain because nothing's actually happened yet. But I would defend the CMA because I think they're in a very difficult place. Not only did you have an election, but so did we. And it appears that Keir Starmer's new best friend is Eric Schmidt, right? And that's a bit weird if you think that you've got Labour Party is a bunch of socialists, right? And Eric Schmidt is a notorious capitalist, right? This is kind of, what are these two guys cozying up together for? And not only that, the whole, last 6 months we've had with our Labour Party here, they've put forward proposals for weakening copyright law. So our musicians, our creators, our, whether you're a TV producer, a film producer, filmmaker, artist, Elton John has come out and said, look, we famously called our minister for Department of Science, Innovation and Technology a moron because he's giving a loosening intellectual property rights, which is extremely dangerous. Because if you loosen the intellectual property rights in the proposal that has been going backwards and forwards between our two houses of parliament, has been to loosen in the favour of AI. Well, all the innovation in the world that may be promised by AI might not be worth the 120 billion or so that we generate from our creative industries. So it's all a bit, what are they doing? Our government is a big question. So the CMA is in the middle of that. I think they are producing very good analysis, which is then capable of being used by those that are best placed to solve the problem for themselves. I cannot imagine that the United States, particularly under this administration, would be happy with the idea that the UK is going to break up Google or the UK is going to break up Meta. They would be offended by the idea that we should even try, because it's an American company, right? And there's a bit of pride in who gets to sort things out. So I think there is a big element of diplomacy in this, which is to point out for the world in English, published for the world, to see what the problems are, what the effects are, and then encourage particularly the US to get on with it. And I think that's been happening quite coherently. I think it's happening perhaps less with the European Commission, that's doing its own thing with its own. They had their own election and they had their own new, people coming in. why the Commission's taken quite so long now that we know where the whether things are landing in the States is perhaps questionable. But they have a big, they've got 500 million people, the big market. The UK is much smaller, right? So they have more political and economic clout in Europe and the US. I do think that, the UK needs to act, but acting before the US is probably unwise because you don't want to put a remedy in place that doesn't work or is inconsistent with anything that's happening in the two major trading blocs.
Right. But just to gently push back on that, because it's not like they're doing something or even considering something. Right now, what I would criticize is that they seem to be doing nothing and walking away from a situation that they helped create. Namely, they set up a process. They effectively required the digital media industry to play along with what I think is a preposterous notion from that we're going to allow Google, the biggest ad company in the world, is now going to own a larger piece of the ad pie and control it and set up rules around it and administer it and charge a fee for it, and all done under the auspices of the CMA. And now when it turned out that they weren't able to build the sports car that they promised to build, in fact, it's not even a Hyundai. It's like a beat up moped that nobody really wants to ride anymore. But now we're at this point. They're saying, oh, well, job well done. And they're walking away. How far off am I from what's actually happened?
Look, Alan, I think that you can say that. I think there is an element of why replace something that works with something that doesn't, that the industry is also guilty of not really calling out. So what you've said just now, well, it's a beaten up moped. If more people had been saying that early on, then Google wouldn't have been able to confuse quite so many people with how brilliant they were and how it was all going to be working brilliantly and how cookies weren't really that good and they don't provide sensible matching and there's lots of problems with handshakes across the supply chain. You've got to come up with a better solution. And I think there's comments on both sides you can make there.
But, and I'm sorry, I feel like I should have someone from the Competition and Markets Authority if they would be brave enough to come on here with me. But so I'm just going to say this. You're right. There wasn't enough pushback on the privacy sandbox, but that was because of the mechanism designed by the CMA made it much more difficult for entities to combine their various feedback. It was one company provides feedback to the CMA, they provide it to Google, Google repositions it, refocuses it, and then comes out with a report saying, hey, don't worry, we got this covered. And we did that for 4 years. So it's hard to point to, well, yeah, the industry didn't complain. Well, that was by design, and the design of the entire mechanism was either created or certainly blessed by the CMA.
Yeah, look, as you said, we didn't apply for a set of undertakings. Google offered a set of undertakings and the CMA took them very quickly. You could say they perhaps took them in haste, and that we then spent a year getting them into a form where they were just about usable. So they became useful. I think they have contributed to the position that we're now in, though, because I think during that process, there's a whole series of tests that were required before anything could happen. So I think they did act as a brake. They did prevent, and then they provided visibility. I would potentially say that without them, the industry would have been locked into a process where Google would have dictated the outcome. It's only after you've moved on to some moped driving machine that broke down that people would have gone, oh, where can we go back? And of course, by that stage, it would have been a disaster. So I think it is,
That is a fair point, Tim.
But look, it's difficult for any authority. I think what's interesting, if you take the view that the only sensible remedies in antitrust are structural, because it's difficult to monitor what's happening, particularly in digital markets, because you can move software around and functionality around and data around. And it's not like, in the old days, they used to separate production facilities in energy from the distribution facilities. That has caused its problems. When does production end and distribution begin? But at least you're dealing with physical assets, right? In software, really tricky. So I guess that tends to suggest you should go for structural remedies, which is really down to the US to do for US companies. And then the enforcement mechanism can roll out around the world. And I think that's what's really going on in the background. A lot depends on Meta. But I would add one thing. So I don't mean Meta, the company, I mean Judge Meta in the search case. But let's say he's issued his order. Google appeals it, right? But when he's issued his order, the UK can then do something very similar. The really big difference between different legal regimes is how long the appeals take. So we did a case, we don't own the act for people against big platforms. So we did a case a couple of years ago, 4 years ago, against the CMA. CMA made what we thought was a bad decision in a merger. And we appealed the case. They made the decision in the August, and we went through to the court. We had a hearing in November, and the judgment came out just after Christmas. And that's a reasonably typical time frame for our appeals process here. Now, that's really fast, right? And to appeal again from there, you can only really do that if you've got a point of law that you can raise. And the courts typically say, no, we won't give you permission to appeal, right? So it's not that you've got a right to appeal because it's like every American's right to wear bare arms or something. It's nothing like that. You
nothing
can't
stronger
do
than that, Tim.
But you see what I'm saying, right? And you guys seem to appeal everything, and it goes on forever. Once the decision's made here, it's quite hard to then appeal it. And I can see the day coming where you're still going through the appeals process in the States, and the orders that reflect exactly the orders that your judge is coming out with are being imposed here, but ours actually having a bit more bite.
Well, let's hope that that's how this ultimately plays out. So this has been a great discussion, but before I let you go, I would love to hear your take on specifically where is the EU Commission in this? I mean, it seems like, they've created the Digital Markets Act, and there are certainly places where they've got investigations into, well, Google and really all of big tech. But where are they sitting? Are they sort of still on the sidelines, or is that 2018 investigation still sort of pending, or we don't know?
So, I mean, the ad tech case, the Commission calls it their ad tech case, that covers quite a lot of the same ground as the Brinkma judgment. We have been through the process. The way that the case starts is that they take evidence. We did a complaint. They take evidence, and they take evidence from Google. They do the investigation. They then issued a statement of objections, and that then gives rise to those that are involved in the proceedings, like Mo, is, and Google, to then provide feedback on the statements of objections. And that part of the process is now came to a close quite a while ago now. So I haven't seen a decision. They don't give it to you until they publish it. But I believe a decision has been written. I think the decision typically would have been issued in November last year, but then we had an election. So we've had a change of commission. So it should be reasonably ready to go. There may be a question of what happens in terms of a remedy. What happened in Microsoft was the decision essentially said, look, here's the problem. What are you going to do to fix it, to the defendant? And that's a smart way of creating a remedy that doesn't then get appealed. Because if the person who's created it tries to appeal it, the immediate reaction is, hey, this is your remedy. What are you talking about, right? It does also cause a bit of an issue, though, because if you're very devious about the remedy that's put forward, you can put something forward which is defective. And the Commission's quite careful about that. I mean, Microsoft, that had maybe 2 or 3 goes round where Microsoft came up with a remedy and the Commission just said, no, that's not good enough. Start again. Right? So that happened a few times. I can see that happening with Google. So you'd see a publication of a decision and then remedies being refined. But if you're sitting in the commission looking at this and you're thinking, well, okay, we've got the decision, we know where it's going to go. Well, what's Brinkmar going to do? Right? You wouldn't want to end up with a dialogue with Google and then you end up with a decision and Google gives you something, you get sold a bill of goods and then they give something else. You want to see, you kind of really want to see what the remedy is in the States. And then if you can, pile on or get more, right? And I think there's an element of that. I've been in commission meetings where, in previous cases where resolution has taken place at national level and they're quite open. They say, well, what did you give? What happened in that case? What do you think? Can we do more? Right? And they do look at that element. So, I mean, I think that coordination is difficult because you've got administrations. So it's the CMA, the European Commission. You've got people who are appointed officials that can talk to each other. But then you've got judges, and they're going to make their own decisions. So you kind of have to wait for the judges to make the decision, then work out how the administration is coordinated afterwards. And that takes us right back to where we were at the beginning, which is how do you coordinate? Well, ultimately, there's going to be technical committees that are going to oversee this. There's going to be the DOJ, there's going to be the CMA, there's going to be the European Commission. Don't forget the Australians, the Koreans, the Japanese, that have parallel cases. So there's going to be a degree of coordination and oversight, and it really does need to be global. So, I think you're seeing the beginnings of, proper global economic governance, I should say, rather than government, governance of parts of where parts of the supply chains are monopolized. You need that in a global, global trading environment.
So what's your sense of how long this is going to take? And not to get to final, because I would imagine final, whatever that is, could be years and years and years away. But at what point do you think we're going to reach the point where the marketplace is going to start to see the light at the end of the tunnel? So where publishers can feel with some level of confidence that they understand what the marketplace is going to shake out.
Well, I think in the first shoe to drop probably is going to be the US Judge Mehta. There's some indication that he's going to give a judgment before August this year, so a couple of months, right? It's pretty soon, and that will be an order. What's been proposed by the DOJ has been quite heavily fought about in proceedings on remedies since September, October last year, and then going right the way through. So you've got a proposed final judgment or a revised proposed final judgment on that case, and he can take into account what's been said in all of the hearings and produce a final judgment. What is then likely to happen is that Google's going to appeal it. So I think the critical first step is what happens pending the outcome of that appeal, because if you're not careful, Google's economic might means that they can just change markets. They can alter the way things work. They can alter the underlying fact base. They could do things that make a lot of his judgment irrelevant, because if facts change, what's the point of ordering people around? And there's so much power there that could be a real problem. So I think some form of protective order, which is quite normal, which is to preserve the status quo pending the outcome of the appeal, would be needed. What does that mean? That means, well, if you're going to sell the browser, it needs to be a thing that we call the browser. You can't add things to it. You can't change it in a way that makes, so there needs to be some degree of control over that to make sure that, if it turns out he's right and he wins, that any appeal against his judgment fails. So effectively the order stands. You don't want to have the person who owns the thing changing it all in the interim period. So you can see quite a lot of scope for a fight about that, but that's kind of going to happen quite soon as the order comes out and the appeal gets lodged. Something similar happened in the Epic case in the States, where, the judgment came out favoring Epic, and then there was an appeal, and then there's an application for a stay, pending the outcome of the appeal. So that type of thing, I think, is going to be early doors as an issue that's going to happen. Same issue comes up in the Brinkmar case, but as soon as you see the appeal can go on for quite a while under US law, as far as I can see and tell. I'm not a US lawyer. So kind of the first thing that's going to be some degree of certainty for your advertising world is what happens immediately on the order being issued in that appeal and the stay or the interim order, what happens there. And if that's reflected in other jurisdictions where it's more difficult to appeal, that's going to start to make a very material difference.
Yeah, that all makes sense. And what we haven't talked about, and maybe we have you on a different time, but we haven't even talked about the separate state AG case, which starts
Texas.
in August.
Yeah.
And that's going to be a really interesting one because there is a gentle person's approach that the DOJ tends to operate under. The states throw elbows. And so that's going to be really interesting because you may see a little bit more blood drawn during this case. And so for those of us who are viewing this, not just because we care about the marketplace, but because we like a good sporting event, this case this summer with the state AGs could be even more interesting.
Yeah, I think that's right. And right at the beginning of that case, there's a very interesting statement from the Texas Attorney General, which is pleading that there were meetings taking place between Google and Apple to discuss privacy and to dress everything up in privacy clothes before the Privacy Sandbox. This was all clearly a orchestrated mechanism for fending off any form of criticism. So it's all in the interest of privacy and security, and we should all, accept everything that's being said because it's going to improve your privacy and security. So I think that's going to be, very important to the way the industry operates, because most of the guff that's talked about on privacy and security doesn't really have any substance behind it. The people who keep invading privacy and making a mess of security tend to be the big platforms.
Absolutely. Well, we're going to leave it there. But Tim, this has been a fantastic discussion. Thank you so much for coming on.
That's a pleasure. As always. Thanks, Alan.
Thanks for tuning in. The Future Media Podcast is a production of Future Media and Ricky Sutton.